breasts are. You know, your children are a product of a penis and a vagina meeting. So how shall we provide sexuality education for children if we cannot call a vagina a vagina? Allow me continue, ladies and gentlemen, because we have limited time. One of the recommendations on this clause is that Uganda should adopt a broad meaning of rape following the spirit of this. There is a case that we are referencing on page 22, so that violators, such as the one that has been given on page 17, are not able to get lesser, what is it called? Punishments. So what we're essentially saying is that this particular provision should have a minimum sentence, because we have had instances where judges are either biased or are able to give lower sentences for the offense of rape, because the law right now only provides for a maximum sentence. A minimum sentence will allow for us to have some sort of uniformity also in terms of issuing out these rulings against these perpetrators. On issues of aggravated rape, we also come up with a very contentious issue, which is on circumstances of persons living with HIV, whereby the Sexual Offences Bill currently provides that if the perpetrator is a person living with HIV, then this will heighten, it will aggravate the offense that is rape. And we are saying, because of all the work that Uganda has done around stigma towards persons living with HIV, I think this particular point should be removed to not let us go back so many years behind. The UN SDGs around that speak about what we are doing around HIV, but also really this current government has so many programs under the Ministry of Health that have spoken about stigma, and the journey that we have taken so far, I think, shouldn't be derailed by imposing HIV as an aggravating factor around sexual offenses. The next one is sexual harassment. I'll not speak about this in detail because it's spoken about in the earlier pages on page 12, and some of the mistakes in here, or some of the recommendations, I think, were sort of handled in the latest version that I saw in December, so I will not go into that. I will then run to page 29. It still speaks about prostitution and prohibition of sexual act with a prostitute. I think we've spoken about criminalization of sex work and the dangers around it, but because of time, I will request that you find the background on page 8. It sort of speaks about why the consistent demand for also the Sexual Offences Bill. We make reference to what was happening in Kenya. We make reference to 1995 Constitution. We make reference to the Domestic Violence Act that was passed by the Parliament, which was also a great effort in addressing some of the issues we had there. We also make reference to the bill of 2016, which did not go far. We make reference to some of the controversial issues that led to the president not assenting to the bill then, and some of the controversies, or the main issue that we got communication about was the fact that there is duplication of offences, and what was referenced was the Penal Code Act. And page 12 and 13 labors to speak about what the Sexual Offences Bill was trying to provide for, what the existing law that we might have thought was being duplicated looks like. So I'll request that if members, you get a minute, you look at those, because we try to sort of make some notes on what is new that we are bringing on board. That can be seen at also page 14 and page 15. Issues of sexual exploitation, issues of sexual harassment that are spoken about in the Employment Act, and etc. I'll quickly get into the analysis of some of the key clauses. You will allow me not to go through each and every one of them, so I'll probably speak about 4 or 5 of them that are major, and then give, I think, some few minutes to the members to sort of make additions to those. The first one that I'd like to make to speak about is on page 18, which speaks about what advanced age means. The bill, as it was then when we were doing this compilation of our recommendations, spoke about the 2019 version, spoke about 17 years, and we were curious to understand why the version drops it by 20 years. Right? We are also mentioning that just like the bill that follows the UN definition of child, it may be safer for us to do the same for what advanced age means, which is 60 years. But also just to emphasize is that I remember in the room then during one of the consultations, members asking, how many Ugandans do you know that are 75 years and above in this country? I don't think we have so many. So let's kindly benchmark what the UN definition is to follow so that we have sort of some order. The next one is also one of the issues that have been very controversial. It's provided for as an offense in our Penal Code Act, then we continue to also criminalize it here. It's very surprising that when we are talking about duplication of offenses, that many members of parliament are usually insistent we leave this issue of prostitution there, right? Yet it's already in the Penal Code Act. And while the other, what we believe are positive provisions, there's been claims that we are trying to duplicate those. So the use of just the term prostitution is something that we believe that we shouldn't continue with. The World Health Organization, the UN, and a lot of work on human rights and conventions that Uganda is part of, and the spaces that we are part of. The term sex work is what has been preferred because it underscores that contribution. We must be honest with ourselves, ladies and gentlemen, that there are families that are surviving because of sex work in your constituents. And you will also bear me witness that there are many, I do not know if members of parliament do this, many men in this room that have perhaps paid for sex before. You have taken a girl to Dubai before, paid for her to have sex with her. Right? So there's a lot of sex work happening, and I think it's time that we actually change the terms that we use, but also recognition of sex work as work. Whether it's something that has not happened before, whether we say it's the morals of our societies, it's actually surprising that the sex work actually happens in the same societies that you keep referencing. So we are also saying, let's just decriminalize and stop just using the word that is prostitution. The next clause is on page 19, which describes what a sexual act is. And just allow me a minute to read these because the recommendation will make sense thereafter. The sexual act is defined as the penetration of the vagina, mouth, and anus, however slight, of any person by a sexual organ. And then D goes ahead to say the unlawful use of any object or an organ by a person on another person's sexual organ or anus. And we are saying that in 2016, when there were so many discussions around sexual harassment in institutions of higher learning, you must remember students from Makerere, students from, I think it was Ndeje, that gave, what are they called, testimonies about how a lot of men right now are not using the penis as perhaps the Penal Code Act must have thought as then. That people are using tongues, people are using dildos, people are using all these kinds of things. And the Sexual Offences Bill seeks to actually broaden what a sexual act is. And we are therefore recommending that we should revise the meaning of a sexual act to make it more comprehensive and include penetration, however slight, between the penis and the vulva of the penis, and penetration, however slight, between the penetration, however slight. We're also saying that we should include that it should be a contact between the mouth and penis, the mouth and the vulva, or the mouth and the anus. Then 3, we are also proposing that we broaden it to include penetration, however slight, of an anal or genital opening of another by a hand or finger or any object with an intent to abuse, humiliate, harass, degrade, or arouse or gratify the sexual desire of any person. I remember in one of the consultations we had with WOPA, someone from DPP's office was mentioning 3 cases they are stuck with because these particular perpetrators used organs that were not hands, they were machines that they were using. One of them was an underage girl. So to be able to have the right ingredients for the DPP to do their work, I think it's important that we broaden what a sexual organ is. On what rape is, which is clause 2(1) of the Sexual Offences Bill, we are proposing that punishment for rape imposes a maximum punishment of life imprisonment, which leaves the court with a discretion to impose a less sentence based on the aggravating or mitigating factors of each case. However, we are noting that a minimum sentence should also be imposed for rape cases to avoid leniency in sentencing.
Procedure, Mr. Chairman.
Yes, please.
Procedure, Mr. Chairman. And we are in mature talk. And some of these media houses do live broadcasting. Mr. Chairman, would it be procedurally right to request the media people to report or cover these proceedings aware of the fact that our children might be watching, or in the alternative, to request the presenters to okusabika ebigambo. I don't know the best English term. So whichever is easier for you, Mr. Chairman, is my humble request. I thank you, Mr. Chairman.
Honorable member, but is there any live coverage?
But Mr. Chairman,
there is no live coverage. It's not live.
But
so
Mr. Chairman,
they will edit. They will edit.
Chair, can I proceed?
Proceed.
Ladies and gentlemen, we are talking about the Sexual Offences Bill, which touches sex, and we know what sex is. We know what an anus is, what a breasts are. You know, your children are a product of a penis and a vagina mating. So how shall we provide sexuality education for children if we cannot call a vagina a vagina? Allow me continue, ladies and gentlemen, because we have limited time. One of the recommendations on this clause is that Uganda should adopt a broad meaning of rape following the spirit of this. There is a case that we are referencing on page 22, so that violators, such as the one that has been given on page 17, are not able to get lesser, what is it called? Punishments. So what we're essentially saying is that this particular provision should have a minimum sentence, because we have had instances where judges are either biased or are able to give lower sentences for the offense of rape, because the law right now only provides for a maximum sentence. A minimum sentence will allow for us to have some sort of uniformity also in terms of issuing out these rulings against these perpetrators. On issues of aggravated rape, we also come up with a very contentious issue, which is on circumstances of persons living with HIV, whereby the Sexual Offences Bill currently provides that if the perpetrator is a person living with HIV, then this will heighten, it will aggravate the offense that is rape. And we are saying, because of all the work that Uganda has done around stigma towards persons living with HIV, I think this particular point should be removed to not let us go back so many years behind. The UN SDGs around that speak about what we are doing around HIV, but also really this current government has so many programs under the Ministry of Health that have spoken about stigma, and the journey that we have taken so far, I think, shouldn't be derailed by imposing HIV as an aggravating factor around sexual offenses. The next one is sexual harassment. I'll not speak about this in detail because it's spoken about in the earlier pages on page 12, and some of the mistakes in here, or some of the recommendations, I think, were sort of handled in the latest version that I saw in December, so I will not go into that. I will then run to page 29. It still speaks about prostitution and prohibition of sexual act with a prostitute. I think we've spoken about criminalization of sex work and the dangers around it, the health dangers around criminalizing sex work, because I know a lot of persons at least agree with us that it's important to recognize that they are quote-unquote prostitutes in our strategies around addressing HIV, but we want to look at it from the economic angle, that there are people that actually survive on this as work. Around defilement, which is clause 16, and that's page 31, we are saying that we need to harmonize the punishments for rape and defilement to both hold a maximum of life imprisonment and a minimum of 4 years. What we are seeking around defilement is to ensure that there is a bit of uniformity. As you might remember, one of the things the Sexual Offences Bill is trying to do is to also harmonize punishments for sexual offences and have them in one place where we can sort of go to. I'll go to page 23, which talks about, clause 23, which talks about child sex tourism, which is on page 33. And in that, clause 23 should be broadened to include the sale of pornography. And just to speak about, for those that may not have this clause, it speaks about any person that prints, publishes in any manner information that is intended to promote or facilitate arrangement for sexual acts with a child, commits an offense and is liable on conviction to a fine of 2,000 currency points or imprisonment for a period not exceeding 10 years of both. And we are saying that we have several laws in Uganda that prohibit child pornography, including the Act on Trafficking, the Computer Misuse, the Anti-Pornography Act, which I know has since been decided upon on by court. And Uganda is part of these UN protocols. We are speaking about the one on sale of children, child prostitution, child pornography, and all those are against the sale of child pornography. So it's only fair that also we include it in here if we are indeed broadening protection for victims of sexual offenses. Payment, which is actually one of the progressive parts of this bill that allows for sort of what we are calling restorative justice. Usually we know you go to court for a criminal offense and then someone is sentenced to go to prison and that's it. They're introducing the issue of compensation. One of the things that we are cautioning about is we know that in many communities where we come from, families actually negotiate, right? Just the Uganda Human Rights Commission launched their report on child marriages, teenage pregnancies, and FGM in the country in December, and almost all the testimonies in the report show you that most of the CDOs and the police officers only get to know about child marriage or teenage pregnancies when the families fail to negotiate and get the right compensation out of the perpetrator's family. So we must approach the issue of compensation very delicately so that it doesn't seem as if we are allowing for compensation to happen in sexual offenses. I think that's it. On page 23, we are speaking about the repealing and saving that's spoken about under clause 46, and we mentioned some of the clauses that are meant to be repealed from the penal code, which is, I think, what the head of state had alluded to as a duplication of the Sexual Offences Bill, which is not the case. Very, very briefly, we may not have spoken about everything that we want about the Sexual Offences Bill, but this particular document will detail and give you the justification for the different proposals that we are giving to this committee. And I know every member has had an opportunity to. Thank you, Chair. I will hand back the mic to you.
Again, to all of you, we thank you for the detailed analysis of the issues in the clauses in the Sexual Offences Bill. Now, we have very few minutes, about 4 or 5 minutes to go. I'll invite colleagues to raise issues, if any.
Rape is a criminal offense which the burden of proof is beyond reasonable doubt. And one of the qualifications being put is that when a rape is proved that actually you committed the offense of rape, and it so happens that you are HIV positive. First of all, the perception of rape is that it's deliberate and planned. Probably, if you look at other provisions, it could even be, you may not even be a first-time offender, but that's just another consideration. So the rape is planned, and he's saying, now that you knowingly knew that you're going to commit the rape, and this person has not only suffered the pain of rape, but is also adding on another suffering of going through the process of HIV management, and aware of the fact that many rapes are not reported immediately, that probably these people would benefit from other mitigating factors like PEP and all those. it's an addition that it should be treated as aggravated, first of all as a deterrence, and for you to be punished severely for this. How does this relate to stigmatization? And I'm asking this because you've not been the first person to relate this to stigmatization. I hold a different opinion, but I would seek to be guided further for better understanding.